Hello and welcome to my YouTube channel. In this lecture, I am going to discussing about part 2 of Vision IAS PT 65 Polity. I already covered part 1 recorded videos for PT 65 Polity. If you missed this video, please go through the playlist and watch this video. Okay. This is disclaimer. You can read carefully. This is not my official channel of Vision IAS. Just whatever credit collecting, processing, distributing, imaging information of current affair goes to the respective institution. Now let's start. Now I already covered first part. Now second part is functioning of parliament, state legislature and local government. Then in the news, first article is internal emergency. I will be discussing about detail in what is internal emergency and what is provision of internal emergency. Why in this news in this year in internal emergency in 2020-24 marks as 15th year of since of internal emergency. What was the starting date of internal emergency is 25th June 1975. Now, what is emergency? If any fundamental right during the emergency was incorporated from Weimar Constitution of Germany. This is important. Okay, emergency emergency took from the Weimar Constitution of Germany, and this provision is outlined in Article 352 in Article 360, Part 18 of the Constitution. Now, rationale behind the incorporation of this provision is to safeguard our sovereignty of the Constitution, unity of the Constitution, integrity of the Constitution, and security of the Constitution, to protect the democratic political system of our country and Constitution. Now, here type of emergency. See, first one is national emergency. National emergency comes under Article 352. President rule comes under Article 356, and financial emergency comes under Article 360. Now, what happened in national emergency? National emergency is divided into two parts. What is two parts? If two parts is first part is if first part when first part is declared. First part is declared when war and external aggression happen. When second part is declared, second part is declared when armed rebellion or internal emergency happen. Now, president rule. It comes under Article 356. These all articles very important for your UPSC examination and maybe PSC examination also. Now, for constitutional machinery, failure of the state, that is called president rule when Article 356. President rule imposed in various times in our country. Now, financial emergency in Article 360. There is the threat to financial stability. Okay, there is no financial stability took in our country. This is important point. Many times in our country, president rule has happened. Then here we ask, can you tell me which state their president rule have not imposed yet? Then it should be state is Telangana. Okay, and that is an important fact about that. Now, what is functionality and what is approval for declare emergency? For declare emergency, you need to approve both house of the parliament with 1 month of issuance. Okay, if approved, emergency remains forced in 6 months and extended to indefinite period with parliamentary approval every 6 months. You need to take every month, every 6 months. You need to approve the parliament both Lok Sabha and Raj Sabha. Now, then this resolution which approved during the continuation of emergency must be passed by a special majority in each house of the parliament. A special majority means majority of total membership, at least two-third member present and voting. Let's consider total 543 member is there. 543 multiplied by 2 by 3 means this member have present, then approval will happen, otherwise it will be returned. Now a special circumstance is also there. If Lok Sabha dissolved during the emergency period without approving its continuation, proclamation survive up to 30 days on the first meeting of newly constitution of the Lok Sabha. provided the Raj Sabha has approved the constitution of meantime. That is all our approval of that. Then how we can return, yeah, how we can revoke the approval? Okay, president can revoke the proclamation anytime through the subsequent declaration. This does not require any parliamentary approval. This is very important point. This does not require any parliamentary approval. If Lok Sabha passes a resolution to disapprove the continuation of emergency, it must be simple majority. See here, UPSC, you have to make a trap here. They will give in approval simple majority and revocation, uh, revocation a special majority. No, you no need to trap at the UPSC. You have to always remember, for approval we need to pass a special majority. For revocation you have to pass a special majority. Okay. Now this is all about emergency. Now what change brought after internal emergency in 44th Amendment Act 1978? For written approval we have to require. For emergency can be proclaimed on the basis of written advice by cabinet to the president. Here fundamental right, restricted scope of Article 359, that is right to protection in respect of conviction of offence, Article 20, a right to life and personal liberty, Article 21, remain enforceable during the emergencies also. Term of Lok Sabha back to 5 years from 6 years by amending the Article 83 and 172. This is very important article. Okay, maybe alternate year, yeah, every year UPSC has asked the question. You have to carefully study and you have to depth study. Next, proceed to next article. Now, removal of Article 275. If gave the power to Government of India to deploy any armed force of Union or other force to deal with any grave situation of law and order in the state. Judicial review. All doubt and dispute arising out in connection with election of president and vice president shall be inquired of decided by Supreme Court. This is all about emergency. Okay. Now proceed to the next article. Next article is about anti-defection law. Now, why in this news? The Supreme Court dismissed the writ petition challenging the constitution of 10th schedule. Now, this is important article, anti-defection law. In 2016, directly asked in which constitution, in which schedule anti-defection law is mentioned. Then here 10th schedule in 2016 they already asked. Anti-defection law provide disqualification of MLA who after being elected a ticket of political party voluntarily giving up their membership. It was mentioned in 10th schedule via the 52 Second Amendment Act 1985. There Rajiv Gandhi government was there. This is important. Any question regarding the disqualification arising out of defection is decided by presiding officer of the House. Who is presiding officer of the House? Speaker. Disqualification happen if a member voluntarily give up the party membership, vote या abstain to vote in House to their direction issued by political party या whip we have to mention. In such act has not been condoned by the party within 15 days. An independent member, we can say nirdaliya sadas, become disqualified if he and she join any political party after such a election. Nominated member become disqualified if he she joins political party after expiry of 6 months from the date on which takes a seat. Exception. What is exception of anti-defection law? Law allowed political party to merge with another party provided two-thirds of its legislature in favor. I want to give example of this line. See in Bihar what happened in last year, last year, Mukesh Sahni party was there. Mukesh Sahni party only 3 MLA was there. These 3 MLA went to the BJP because all 3 MLA want to go to the BJP. That is here anti-defection law was failed. If person is elected a speaker of Lok Sabha or chairman of the Raj Sabha, he could resign from his party and rejoin the political ones. She dismiss his post. Presently, law does not provide any time limit which a speaker or presiding officer have decided to anti-defection case. So now, what was the judgment and what is the judgment related to anti-defection law is? First is important is Kyoto Holan case 1992. In this case, Supreme Court told like that A speaker decision under the anti-defection law is subject to judicial review. And second one is 2020 case, Khesam Madhachandra case 2020. In this case, Supreme Court told like that disqualification petition under the 10th schedule should be normally be decided within the period of 3 months from date of filing. These two cases there. This is important case. You have to remember. This is all about anti-defection law. Next, proceed to next article. Next article is proportional representation. Then in sixth class book only mention what is difference between first past post and proportional representation. These all are parameter: geographical unit, representation, voting process, seat distribution, example, benefit and concern. Okay, what is difference between first past and post and proportional representation? See, country is divided into a small geographical unit is called constituency or district. Like our Madhubani is a constituency, Benipati is a constituency, like that. Proportional representation, here large geographical area are demarcated as a constitution. Entire country may be single constitution. Okay. Now representation. In first past the post is every constitution elects one representative. Proportional representation, more than one representative may be elected from one constituency. Voting process is for first past the post is voter votes for candidate. In proportional representation, voting process is voter votes for party. First past the post seat distribution is party may get more seats than votes in legislature. Winning candidate may not secure majority 50 plus 1 votes. In proportional representation, seat distribution is every party gets seats in the legislature in proportion to the percentage of votes it receives. Example of first past the post is India, Canada, US and UK. Proportional representation is Israel and Netherlands. What is benefit of that? For first past the post is simple to understand for common voter, a stable government, different social group come together to elect locally. What is benefit of proportional representation? Ensure representation of all parties, fair treatment of minority party, fewer votes are wasted. For people reference and taken into account. What is concern of both the system? Concern of first past the post is over the underrepresentation of political parties compared to their vote share does not ensure due to representation of minorities group. What is concern of the proportional representation is can lead the fragment legislature with multiple small parties may result in coalition of government which can be less stable of parliamentary democracy. This is all about a difference between first past and post and proportional representation. These all are mentioned in the class 6. Okay. Types of proportional representation system: single transferable vote system, list system, mixed member proportional representation system. In single transferable vote system, voter rank candidate in order to preference. And the second one is adopt a election of member the Rajya Sabha या state legislative council या vice president या president. In list system, voter vote for party. It is not vote for individual and get parties get seat in proportion to their vote share. In mixed member proportional, maintain balance between stability and proportionate representation, like example Germany and New Zealand. And one candidate elected through a PTP system from each territorial constituency. There are also additional seats that are filled based on various parties' percentage of vote. That is all about these all article. Next article is parliamentary committee. Why in this news? Recently in Lok Sabha in last year 2020-24, motion from Public Account Committee and Estimate Committee have formed. Then what is parliamentary committee? Is appointed elected by House या nominated by Speaker, which works under the direction of a Speaker. Its present report to the House, Speaker and Secretariat, for which provided Lok Sabha Secretariat. Public Account Committee have their origin in the British Parliament. This comes under Article 105. This will deal with privileges of MP. And Article 118 gives parliamentary authority to make rule to regulate the procedure of conduct the business. Types of parliamentary committee. Parliamentary committee is divided into two types. One is ad hoc committee. Second one is a standing committee. Okay. Ad hoc committee is appointed to a specific purpose in case exist when they finish task assigned to them. Example, Railway Convention Committee, Joint Committee for Food Management and Parliament. Standing committee, permanent and regular committee, which are constituted from time to time. These examples are financial committee, department of related standing committee, and some other committee like committee on subordinate legislature. This is all about parliamentary committee. I hope you understand this topic. Now these all are topic in detail. Public Account Committee, it formed in 1921. Montagu Challenge for Reform is mentioned. It constitutes not more than 22 members. 15 members are from Lok Sabha, 7 members for Rajya Sabha. What is functionality of that? It adding the revenue and expenditure from Government of India. What is Estimate Committee? First time it was constituted in 1950. Total 30 members is from Lok Sabha. This is trapping question. You have to remember. Star marks is there. What is function of Estimate Committee? Suggest alternate policy for bring out efficiency in administration, to examine whether money is well laid out within the limit policy or not. Parliamentary Committee on Official Language, what happened? Now Home Minister या Corporation Minister are re-elected chairperson of Parliamentary Commission of Official Language. It's constituted in 1976, comes under Official Language Act 1963, and it's adopt Hindi in official purpose to constitute committee 10 years for commencement of this act. Total 30 members are there, 20 from Lok Sabha and 10 from Rajya Sabha. And according to system of proportional representation and single transferable vote, what is functionality of there? It review the progress made by Hindi on official purpose of union, submit recommendation by the president. Committee on Privileges of Rajya Sabha. Now what happened in Privileges Committee of Rajya Sabha? 12 opposition MP guilty misconduct of disrupting House proceeding. Then what is the functionality of Committee of Privileges of Rajya Sabha? It consists of 10 members nominated by Rajya Sabha Chairman, Vice President. It is responsible for investigate and addressing breach of parliamentary privileges, parliamentary peacefully we have conduct or not. Parliamentary privileges a special right to immunities grant to both of House of Parliament and member to perform the functionality efficiently. This is about Committee on Privileges. In case of Lok Sabha, Privileges Committee consists of 15 members from nominated by the Speaker. Chairman of the committee shall be appointed by Rajya Sabha Chairman amongst the member of committee. Now Cabinet Committee. Union government constitute 8 Cabinet Committee. That's why it is a news. Cabinet Committee is extra constitutional in nature. It is not mentioned in Constitution. This is important point, not mentioned in Constitution. And it's formed in Government of India Transaction Business Rule 1961. Okay, this makes use cabinet system facilitate decision making in a specific area. Political Affair Committee, Economic Affair Committee, Appointment Committee, and chaired by Prime Minister, and Parliamentary Affair Committee, Home Minister. Then this may be important question. They are UPSC can give Political Affair Committee, Economic Affair Committee, and Appointment Committee are comes under the Home Minister. No, it not comes under the Home Minister. It comes under the Prime Minister. Okay, Parliamentary Affair Committees comes under the Home Minister. It include only Cabinet Minister. Okay, however, non-Cabinet Minister are not included. That's why maybe this is important question. Maybe this asks. Okay. Now, next article is Secretariat of the Parliament. Why in this news? Now you know this year, in last year, 75-year completed of our Parliament. Parliament Secretariat has been custodian to procedure, president and legislative knowledge of two hours. This news is not important. What is constitutional provision? Article 98 mention House of the Parliament shall give separate secretariat staff. Parliament by law regulate recruitment, condition of service of person appointed to the secretariat staff of either house. However, so far no such law has been passed. It allows creation of post common of both houses of the Parliament. Article 187 mention makes similar provision for Secretariat of State Legislature, Council of State of Secretariat, Parliament Secretariat, House of the People were set up when both houses come into existence 1950. Their name was changed in 1954, Rajya Sabha Secretariat and Lok Sabha Secretariat respectively. These secretariat of both houses has been divided into 10 services on the functional basis like legislative, executive, administrative, verbatim reporting service etc. Secretary General of both the House rank equivalent to the Cabinet Secretary. This is important point. Secretary General of both House holds rank equivalent to the Cabinet Secretary. However, table of precedence, Cabinet Secretary placed in 11th position, whereas Secretary of Lok Sabha and Rajya Sabha 23rd position. Now, what is functionality of Secretariat? Secretariat assistance for effective function of Parliament House, service various parliamentary committee, prepare research and reference of material and bring out of the various publication, payment of salary and other allowance, Secretary General at the advice of presiding officer, prepare for publish record of day by day to proceeding of the House. What is difference between structure or a secretariat, Lok Sabha secretariat or Rajya Sabha? Chairman is Lok Sabha speaker, chairman is Rajya Sabha speaker, administrative head is Secretary General, administrative head is Secretary General. Recruitment and condition of service governed by Lok Sabha Secretariat. Recruitment Condition Rule 1955. Recruitment and condition and service rule by Rajya Sabha Secretariat. Recruitment Condition Service Rule 1957. Other important news. Other important news in Cabinet Secretary. Appointment Cabinet Committee approved by appointment of new Cabinet Secretary within 2-year tenure starting from 30 to 2024. Cabinet Secretary is a seniority come merit basis. It comes under whoever join first, they will become Cabinet Secretary first. You can become, if you qualify the IAS examination, if you go to the senior post, you will become the Cabinet Secretary. This Cabinet Secretary is responsible for administration, Government of India Allocation Business Rule 1961 and Government of India Transaction Business Rule 1961. This is in interministerial coordination, iron out of difference among minister and department. Cabinet Secretary is ex officio chairman of Civil Services Board. Cabinet Secretary has no authority over working department. Cabinet Secretary is regarded as primus inter pares among the union government. Now, President address Parliament. This is in the news. Parliament addressing. Article 86 allow President to address either House of the Parliament or both House of together. President has not so far addressed under this provision. Article 87 provide two instances when President especially address both House of the Parliament assembled together. When they address first beginning of first session after each general election and beginning of first session of each year. Originally, Article 87 Clause 1 required President to address both House of the Parliament at commencement of the every session. Constitution First Amendment Act 1951 amended this provision. Last article is oath member of Parliament. You also know last year, uh, many member of Parliament is elected. That's why in the news. Article 99 deals with oath of office of MP to be the president of some person appointed by him. The form of oath is provided by which schedule? Third schedule. This is maybe important. Oath is mentioned in third schedule. Article 104 provides penalty for member if he sits in the house without oath. Exception under this rule is an individual can become a minister without being elected to parliament and he or she can take part of the proceeding of house without having power to vote. Oath can be subscribed in English or any other 22 schedule language. This is all about second part of the Vision ISPT Polity lecture. I already uploaded first part. If you missed this lecture first part, please go through and watch that video and again proceed to this video. I hope you like this video and I hope I want to, with the help of this lecture, I want to uh, contribute your journey. Okay, it will be helpful for you to in PT prelims examination. Okay, if you like this video, please share and subscribe my YouTube channel. Thank you guys. Thank you for watching this video. Jai Hind, Jai Bharat.